as late as during the course of this week to try and facilitate a joint meeting of experts. There's no suggestion that that can't happen. We say, of course, it's practically difficult given how late in the day we are. But, my lord, the plaintiffs first requested that a joint minute be prepared as early as 3 December 2015, even before the expert summaries were exchanged. That, your lordship finds at page 15 of file 1.
When you say file 1, that's this volume here. Volume,
yes.
Are you referring to volumes now?
We'll call them volumes. Yes, it was volume 1.
At page?
Page 5. Wow. What makes it confusing is that within the files there are volumes.
That is why I'm asking.
So I'm referring to file 1, which has, firstly has the pleadings.
But that makes it difficult for me to find, because on the spine of these lever arch files, it says court file 1, court file 2 of 6, and so on.
Yes.
So now if you tell me now volume.
No, okay, so I'll refer to file, my lord. I'm referring to court file 1, which should accord with what your lordship has. And in court file 1, you will firstly find the pleadings. After the pleadings, your lordship will find the pre-amendment pleadings bundle. Then your lordship will find the pre-trial documents bundle. And it is the pre-trial documents bundle to which I'm presently referring.
That's at page?
Page 15. Where this, my lord, is the plaintiff's pre-trial conference agenda.
No, but now you're referring to page 15.
Yes, my lord.
But in this volume where I have the pre-trial bundle, oh, I have volume 2 here now. Volume 1, you said?
Yes, volume 1 of the pre-trial bundle. I'm sorry for the way it's been constructed, my lord. There was some toing and froing between the parties as to how it...
Page 15.
Yes.
Yes.
Paragraph under the heading Joint Meeting and Minutes of Experts. This is the plaintiff's pre-trial conference agenda, which was delivered in December 2015. And there in paragraphs 4.1 and 4.2, it states, the plaintiffs request the defendants to state whether they agree that the joint meeting of experts may occur via tele or video conference rather than in person. Should the defendants not be amenable to the aforesaid, they are requested to place the reasons for their refusal on record. And then, my lord, there's numerous instances where the plaintiffs attempt to procure a meeting of the experts. I don't, Lord, I've asked members of my team to put together a list. I don't want to burden your time, my lord, by going to each and every reference, but I'll give you the references.
Yes.
Starting in May of this year, 2017, page 216, my lord, paragraph 6. The plaintiffs state that they need to ventilate the joint minutes dispute. Paragraph 7, the plaintiffs request a meeting so as to reach agreement on a joint minute. In a pre-trial conference agenda for the 8th of May, at page 220, paragraph 1.3, the plaintiffs propose the compilation of what's commonly referred to as a Scotch schedule. I'm not sure if your lordship is familiar with the concept,
yes,
but it's quite often used. Yes. The plaintiffs also, at paragraph 1.4 of that, propose that parties come to an agreement as to the overlap and the distinguishing features of the various experts' fields. In a pre-trial conference minute of the 8th of May 2017, page 232, specifically page 234, The 8 defendants poo-poo the idea of a Scotch schedule on the basis that they believe there would be too much intervention in that process by the legal representatives, and that the various experts ought to be left to themselves to decide how best to deal with everything. At page 234, there is a directive, my Lord, from the Deputy Judge President to the effect that joint minutes are to be delivered by the 9th of June 2017. And in the event of there not being a minute, then it should be explained to the trial judge. In a pre-trial conference agenda of the 6th of June, page 246, specifically page 247, para 6.1, the plaintiffs place on record that the defendants have not accepted the plaintiff's suggestions in arriving at a joint minute. Para 6.3, the plaintiffs seek the defendants' views if the joint minutes cannot be provided by the due date being the 9th of June. At para 9, page 255, all of the parties agreed that the deadline for filing the joint expert minute would not be reached. Lord, in the pre-trial minute for the 6th of June, in paragraph 9 and subparagraphs it says this: in respect of a joint minute of the meeting of experts, it was agreed that the previously proposed deadline would be missed. In paragraph 9.2, it's recorded that the representatives of the plaintiffs state that they have been proactive in proposing methods to cater to witnesses being separated geographically, but that the defendants had rejected their proposals. Paragraph 9.3, the defendants again rejected the idea of a Scotch schedule and proposed that the expert witnesses ought to contact one another directly and discuss or debate matters as they saw fit. The representatives of the plaintiff, it is recorded, therefore proposed that a draft letter be distributed between representatives as ultimately intended to be sent to all expert witnesses once a formulation was agreed upon. The plaintiffs then proactively, my Lord, prepared that letter, which is intended to then be delivered to all of the experts with instructions on what they ought to do to try and reach agreement or disagreement as the case may be, and record that in a joint minute. And that letter was circulated, my Lord, by the plaintiffs to the defendants. However, in a recordal of a meeting of the 22nd of June, it says this under expert witnesses: despite the plaintiff's repeated noting of prejudice in this regard, the parties reached agreement at the previous pretrial conference held on 6 June 2017 that, sub 2, a letter would be sent to all experts witnesses in respect of the compiling of a joint minute. So by that date, despite the plaintiffs having circulated the draft letter, nothing had yet been done. On page 270, para 7.2, it's recorded that as at date of service of this agenda, the defendants have not yet reverted on the contents of the plaintiff's draft letter to experts, despite the plaintiffs sending same on or about 13 June, it says 2016, but that's obviously a mistake, it's 2017.
Yes.
The plaintiffs sending the same on or about 13 June 2017, and to the extent that this situation persists by the date of the pretrial conference, such matter will be discussed. Then, my lord, in the plaintiff's response to the 1st to 7th defendants' inquiries of 21 June 2017, page 288, para 20, the plaintiffs indicate that they are amenable to getting the experts to arrive at a joint minute. Page 288, para 21, the plaintiffs reiterate that they have been proactive and timeous in providing proposed solutions to achieve a joint minute of experts, but defendants have not accepted any proposed solutions as at date hereof. So the plaintiffs, my lord, have been really trying to get the parties together, to get the experts together to discuss their various points of agreement and disagreement. And it's certainly not for lack of effort on the part of the plaintiffs that as we sit here today that still hasn't happened. Had it happened, of course, my lord, the experts, had they had any difficulty with the annexures to the expert summaries, could have raised those difficulties, might very well have been explained. The defendants, with respect, are the architects of their own misfortune in that regard. Then, my lord, although it is raised in the affidavit on behalf of the 1st to 7th defendants, it was not dealt with by a learned friend for the 1st to 7th defendants, Mr. Sabashi SC. But I didn't understand her to abandon the point. And that is this notion that the experts are not entitled to rely on articles which are not authored by them. Now that, my lord, is simply wrong in law and has been dealt with comprehensively by our courts. One need merely, or one could as a starting point visit the well-known textbook on evidence, Hoffman and Zeffert. And I'm reading from the 4th edition at page 101, where the author says this: "There is no general rule that the expert's knowledge upon the subject matter of his evidence must derive from personal experience rather than from reading. Opinions on scientific matters usually involve reliance upon data provided by others. As Wigmore said, science is, and I quote, a mass of transmitted and collated data from numerous quarters. The generalizations which are the result of one man's personal observation exclusively are the least acceptable of all." And the author refers to the judgment of S versus Kimimbi, which I'll refer to, quote from in a moment, where Vartameyer J accepted the opinion of a fingerprint expert that 7 points of identity were sufficient to identify a fingerprint beyond reasonable doubt, given on the basis of general experience in South African Criminal Bureau, based on what they had been taught. And in that judgment, Lord, if I could read, it's S versus Kimimbi, K-I-M...
S versus?
Kimimbi, K-I-M...
Yes.
I-M-B-I. It's an old judgment, Lord. This is settled law. 1963, volume 3, SA Law Reports at 250, decision of the Cape. And I'm reading, my lord, from page 251 next to the letter H. And I quote, "It would seem clear that no single individual, even though he had examined hundreds of thousands of fingerprints or palm prints, could from his own observations alone make such a statement with certainty. As is pointed out by Wigmore in his treatise on evidence, the data of every science are enormous in scope and variety."
All right, we're currently bringing you these live proceedings from the Pretoria High Court, and that was the matter of the legal...
We must every day treat as working truths. Hence, a reliance on the reported data of fellow scientists learned by perusing their reports in books and journals. The law must and does accept this kind of knowledge from scientific men. On the one hand, a mere layman who comes to court and alleges a fact which he has learned only by reading a medical or mathematical book cannot be heard. But on the other hand, to reject a professional physician or mathematician or the like, because the fact or some of the facts to which he testifies are known to him only upon the authority of others would be to ignore the accepted methods of professional work and to insist on impossible standards. That judgment, my Lord, has been accepted in this division, approved in this division, in the judgment of S versus Melindi, 1983, volume 4, SA Law Reports at page 99. So dealing with this particular complaint, the complaint in essence is you can't rely on the work of others, journals authored by others. Now we have for the first time this morning, my Lord, been provided, not in hard copy, but with electronic access to what the 8th defendant has called its trial bundle, given to us for the first time today in electronic form. Yesterday there was an attempt to provide the link from which we could download it, but the link didn't work. So we got the link for the first time today. And of course, I haven't been able to have anything more than a very cursory or perfunctory glance at what's contained in it. But it appears, my Lord, to be hundreds of documents, thousands of pages of journal articles, which are authored not only by the 8th defendant's experts. So the complaint really, my Lord, is not you relying on the journals of other experts, it's that you giving us advanced notice of the journals you're relying on. That, with respect, is absolutely nonsensical. And yes, and in order to simply illustrate, my Lord, the vexatious nature of the application on this point, if I could direct your Lordship's attention to what the defendants say in their expert summaries. I accept that they're not the summaries which are on trial, but I do it for illustration in order to demonstrate the vexatiousness of the application. Lord, all of the defendants' summaries are in file 5. In file 5, my Lord, if I could ask your Lordship to turn to page 5.
Yes.
Bear in mind, my Lord, the complaint is you're referring to the work of others, and you've given it to us in advance. This is a report on cannabis and its use in South Africa prepared by the 1st to 7th defendant's expert, Mr. David Beyer of the Central Drug Authority. And he sets out a number of conclusions. But what is interesting, my Lord, if your Lordship looks, for example, at page 7, says, under the heading, how big is the problem in SA? It says, statistics in South Africa are scanty. But the South African National Council...
I must interrupt you.
Page 7.
You said at page 7, you
Top of the
started
page.
off...
There's a heading, how big is the problem in SA?
Oh, yes.
Just below that. He says, statistics in South Africa are scanty. But the South African National Council on Alcoholism and Drug Dependence notes that in 2014, more than 24% of admissions to treatment centers, etc. So, I mean, what does that mean? They're referring to some statistic by some body. They don't give us what it is. They don't tell us who they are. They don't tell us how those statistics were arrived at. Goes on, they refer to the Sekendu brief in the second paragraph, volume 18.1. They don't give it to us. Next paragraph, they say the National Institute of Health reports that 1 out of every 6 adolescents who try cannabis will develop an addiction. Where do they get that from, my lord? They don't give it to us. Where did they report it? Who reported it? What did they use to report it? It gets even worse, my lord. Page 8. Now, there are reference lists, my lord, at the end of this, but they, we must now... The complaint is that we've given them documents to trawl through. What we're expected to do is find these documents on the internet. Most of them, of course, are not publicly available. You have to subscribe to them, download them, and then trawl through them to find what they're referring to. Page 8, the use of magnetic resonance imaging in support of, quotes, a study conducted in Australia. Now, what are we to make of that, my lord? A study by who? People sitting around a campfire?
My lord, I'd like with the apologies to my learned friend for having to introduce him. Lord, we've had this cry about time. There's no application against any of the defendants' expert notices. The Lordship, with respect, needs to realise our learned friend. This is a waste of time. I don't know how my learned friend or any approach to ours is going to be answered when we've had no preparation.
Well, I think what Mr. Mahon said before going on to this, the defendant's expertise, that he wants to use it as an illustration of the vexatious nature of the application by the defendant.
My Lord, with respect, he can't do that. He's given no notice to us that he's going to attack, and he himself conceded this application is not about our expert notices being on trial, it's his right now. He can't do this, my Lord. It's an abuse. That's what vexatiousness is, an abuse of the process. He's abusing the opportunity, my Lord, and it's wasting time. My Lord, with respect, it's, I don't know how my learned friend must deal with it. I don't know what he's going to have to say about ours, but it's going to be a waste of time. Then he must put in an application and do it properly.
I'll hear from Mr. Mahon.
I don't intend to take many more examples. I'll cut it down, my Lord, but this is a recurring theme throughout many.
My Lord, with respect, my Lord, your Lordship hasn't made a ruling on this. My learned friend can't just move on. With respect, my Lord.
Yes.
Sorry, my Lord, I interpreted when your Lordship said, I'm happy. I thought your Lordship meant
No,
I should continue.
no, I didn't say I'm happy.
I beg your pardon.
I said Mr. Mahon.
Oh, yes.
Yes.
May I continue on this theme?
No, do you wish to answer to the
I see what you
objection?
mean. Yes, thank you, my Lord. I've made my submissions. I don't do it, my Lord, for the purposes of attempting to strike out their notices. That would be self-defeating. The law, as I will submit to your Lordship, is that that's not the correct procedure. The correct procedure is to see what evidence is led and to object if there's an objectionable amount of evidence which is being led, or if the nature of the evidence is objectionable in some way.
Yeah.
So, my learned friend, in an attempt seemingly to prevent me from demonstrating the absurdity of the defendant's argument, is trying to compartmentalize my submissions into a submission in favor of a strikeout. That's not what it is. It's to illustrate the absurdity of their argument and the vexatiousness of the application.
Yes. The objection.
I don't know how my learned friend makes that submission. So when I object to him moving off the subject matter of the application before your Lordship, he says we're compartmentalizing. That's not what's happening, my Lord. I've said to your Lordship, my learned friend is wasting time. He's moved outside the scope and purview of the application before your Lordship. If he wants to attack our papers, then he must bring an application. He can't tell you that the way we've drawn our papers, well, this is dealing with the states at present, the 1st to 7th offences, that proves vexatiousness. No, my Lord. Other things might demonstrate vexatiousness, but there's no attack formally against these notices. My Lord, with respect, there's no argument. Your Lordship, with respect, needs to contain the argument to
Mr. Willis?
before your Lordship.
Mr. Mahon indicated he wants to simply illustrate. I overrule the objection.
As your Lordship needs.
Lord, I'll cut it down in
Yes.
order to assist my learned friend. But if I could turn your Lordship in the same report, page 9. In the third line, in the middle of that line, it says, recent research on the teenage brain. What research? We don't know. What teenagers? How effective was the study? We don't know. In the 8th line, there's reference to a New Zealand study which led an international team of researchers. Vague in the extreme. What are we to make of that? Clearly, they're relying on the opinions of others, but at least in their case, they've had the benefit of being precognized of what those journal articles here. Here, there's simply oblique references to them. This is a recurring theme, my Lord, throughout the defendants' reports. Your Lordship will see that, and it is most severe, my Lord, in the 1st to 7th defendants' reports, but also particularly in the report of Mr. Evans, the 8th defendant's expert, who's an American attorney who has dealt with drug addiction. So, on the question of the content of the summaries, they complain that the summaries don't say what evidence will be led and that they have annexes which are irrelevant. Now, the rule doesn't require that it must say what evidence will be led. The rule requires, quotes, a summary of opinions and reasons therefore. The rule does not require, quotes, a full report. That, my Lord, is from the judgment of Ndlovu versus the RAF, 2014, volume 1. SA Law Reports at page 415 of the South Gauteng Division, specifically page 437 next to letters G to H.
Sorry, it's specifically at?
Page 437, G to H. No.
Yes.
As to what the rule requires, my Lord, I would refer to the well-known judgment of Doyle versus Centrabul. I'll give that citation to your Lordship as well. Because this, I think, speaks volumes to what we're dealing with at present.
Which case are you referring to?
Doyle, D-O-Y-L-E, versus Centrabul Cooperative, 1993, volume 3, SA Law Reports at page 176, Southeastern Cape Local Division. The judgment of His Lordship Justice Mullins, there are 4 paragraphs which are relevant. The first is on page 181, next to letter C. The judge says this: a practice has developed. Instead of providing a summary of annexing to the Rule 36.9b notice the whole of the expert's report furnished to the party who sought his opinion. This may in many cases be unobjectionable and even desirable. It is not, however, a practice which should be observed invariably and without thought as to whether a summary would be more appropriate. In fact, one suspects that in many cases it is the easy way out, adopted without thought of the consequences or possible complications arising therefrom. At page 182, next to the letters E to F, this is important. Makes this observation. The issues between the parties that the defendant should have been prepared to meet were those set out in the particulars of claim, and particularly the description of the plaintiff's injuries as described in paragraph 6 thereof. If the medical reports annexed to the particulars of claim did not bear out such allegations, it should nevertheless have put the defendant on his guard that further medical evidence might be forthcoming before the trial. So, by way of illustration, my Lord, you can't say that because the contents of one's expert summaries contradict each other or don't support the case, that therefore they should be struck out, you argue that they don't support the case when it comes time to argue that. And if, of course, something is sought to be introduced during evidence, which is prejudicial to the other party because they haven't been sufficiently precognized, that's a different story. Then they will raise that and they will object to the evidence, and the judge in his wisdom will decide how to deal with the further progress of the matter. Goes on to say at the top of page 183 of the judgment, defendant could, however, in no way have been taken by surprise in regard to the field of expertise of Mr. Jordan. At most, this is important, my Lord, at most, defendant was faced with certain minutiae of Mrs. Jordan's report, which expressed views regarding the relative consequences of the 2 whiplash injuries. Further down the page, the time limits provided for in Rule 36.9 were not designed to provide a litigant with a tactical advantage over the other party. Each party must prepare for trial individually. As correctly pointed out by Mr. Liebenberg, Rule 36.9 does not, as in the case of certain other rules, provide that a plaintiff must take certain steps within a prescribed period, whereafter the defendant has a further period to respond thereto. The rule contemplates a simultaneous exchange of expert summaries. Now, that rule was departed from, my Lord, by the directive of the Deputy Judge President. Directed that the plaintiffs deliver their expert summaries quite far in advance, by the 30th of September 2016, and that deadline was met. The memory serves, my Lord, the defendant's summaries were due at the end of March 2017. And it's no coincidence, my Lord, that the first complaint about the summaries being annexed to the plaintiff's, and I beg your pardon, the annexures being annexed to the summaries of the plaintiff's expert witnesses comes pretty much a week before that deadline. They had done nothing, clearly, until they woke up and decided that now they need to meet the deadline, and then they, for the first time, communicated this complaint about the summaries. And when the complaint was communicated, the response was, we don't agree, the summaries are fully compliant, exercise whatever remedies you deem fit. And here we sit, my Lord, 10 months later, an application served on the first day of trial.
You were reading that last extract from which paragraph?
Doyle versus Central Group.
Yes, but at page 183.
Page 183, next to the letter A, all the way through, my Lord, to E. It ends, my Lord, with a quote from another case, saying the rule was not designed to encourage one party to wait until 10 days before trial in order to satisfy himself that his opponent does not intend to call expert evidence before himself deciding whether or not to call expert evidence on a material issue.
I take it you will be dealing with what I understand to be one of the complaints of the defendants, that they are expected to now go through all the articles.
Yes.
And that is you will deal with
yes,
it.
Yes. Yes. So what the rule requires, my Lord, is it requires a summary, it requires opinions, it requires reasons. And on the Coopers and Deutsche Gesellschaft case, it was held that what this means is the following, quoted from the judgment, Lord: the sum and substance of the facts and data which lead to the reasoned conclusion. That's what the rule requires. So if we look, my Lord, at whether they apply, let's see if we've given the summary of the opinions and reasons therefore, comprised of the sum and substance of the facts and data. If your Lordship turns to file 2. Let's start, my Lord, with the expert summary of Dr. Abrams. It commences, my Lord, the summary commences on page 4. On page 5 is firstly really a summary of the expert's qualifications. His CV is annexed as Annexure A. Talks about the numerous clinical trials that he's done. Talks about studies he's done, chapters he's co-authored, the fact that he's a scientific advisor to a number of cannabinoid-based pharmaceutical companies, and a member of the National Academies of Science, Engineering and Medicine Committee to evaluate the health effects of marijuana. It says what he's read or authored in paragraph 1.1, and it lists a series of journals which are attached. Right. He says, this is a summary, the sum and substance of my opinions and why I say that, and the data you can see inside the articles that I attach. Cannabis and HIV. He makes the observations in paragraph 3.1.1 through to 3.1.6, by and large pointing out that based on studies, cannabis has been shown to assist in the management of painful HIV-associated sensory neuropathy. Now let's look at whether there's data to support that conclusion. We turn to Annexure D, to summary at page 67.
Yes.
This is entitled Cannabis in Painful HIV-Associated Sensory Neuropathy, a randomized placebo-controlled trial. So it tells you what it is. It's a trial. It tells you who are the scientists involved, a number of them, including Dr. Abrams. It tells you what the objective is. It says, abstract, objective, to determine the effect of smoked cannabis on the neuropathic pain of HIV-associated sensory neuropathy and an experimental pain model. And it tells you the methods. Prospective randomized placebo-controlled trial conducted in the Inpatient General Clinical Research Center between May 2003 and May 2005, involving adults with painful HIV-associated sensory neuropathy. He tells you how the trial was conducted. Patients were randomly assigned to smoke either cannabis, 3.56% tetrahydrocannabinol, or identical placebo cigarettes with the cannabinoids extracted 3 times daily for 5 days. Primary outcome measures include ratings of chronic pain and the percentage achieving greater than 30% reduction in pain intensity. Acute analgesic and anti-hyperalgesic effects of smoked cannabis were assessed using a cutaneous heat stimulation procedure and the heat capsaicin sensitization model. It tells you the results. 50 patients completed the entire trial. Smoked cannabis reduced daily pain by 34%. Median reduction IQR, and there's some jargon there, a little bit the scientists no doubt can understand. He compares it to the placebo. He says no serious adverse events were reported. Concludes, smoked cannabis was well tolerated and effectively relieved chronic neuropathic pain from HIV-associated sensory neuropathy. The findings are comparable to oral drugs used for chronic neuropathic pain. That is a summary of what follows in the article. Now, by my own admission, my Lord, a lot of this is above my pay grade.
Out of here?
Above my pay grade.
Oh.
Beyond my understanding. We leave that to the scientists.
Yes.
But we would no doubt be criticized if we didn't provide the science behind it. When we provide the science behind it, the complaint is, but now we have to read all the science. Lord, with respect, it's not a valid complaint. And the privilege, my Lord, of being able to tell counsel that they ought not to be trawling through voluminous pages of documents is the reserve of judges, my Lord. That is a privilege which a judge enjoys. Counsel are not unaccustomed to trawling through documents, my Lord. It's what we do. They suggest, my Lord, curiously, that what the plaintiffs ought to have done is, rather than attaching this report, it should have been separately filed, perhaps in a discovery. Well, surely, my Lord, they're not suggesting that if that had been done, they weren't going to read the discovered documents. They would have to read them. We've given them the document on which we rely. They have given us documents for the first time, they being the 8th defendant, given us documents for the first time today. We still don't have, incidentally, from the 1st to 7th defendants. So their complaint is we're giving them too much notice, and therefore it's making their work harder because they need to read through the stuff.
I rise with utmost reluctance. This is very uncharacteristic of me. But I rise because I'm about to reach the end of my tether. Given the intemperate language and innuendos that are cast by Mr. Mao, two about his senior colleagues. My Lord, this is a very important matter that involves constitutional issues that has evoked public interest and emotions. There are professionals in here, experts. What are they to make about the administration of justice? When counsel rises and say whatever he wants about his colleagues, he used the words such as, this is fiction or nonsensical in relations to statements made by his senior colleagues. My Lord, this is unacceptable. I would appeal to you, my Lord, to intervene.
Yes.
I just wanted to place this on record.
Yes. Thank you, Mr. Bokaba. Mr. Mahon, any response to that?
Well, I've heard what my learned friend says, but Lord, certainly not my intention to be discourteous or unkind to my colleagues. I thought I'd made it clear my submissions were directed not at my colleagues, but at their clients.
That's not correct.
Can Mr. Mahon finish? And you.
Yes, my Lord, I thought I had made it clear that my submissions were not directed at my colleagues. When I say, for example, my Lord, that a proposition is nonsensical, I do so, my Lord, mindful of the respect my colleagues command of me. But if the proposition does not pass the basic test of rationality, my Lord, I'm enjoined to point that out in furtherance of my client's interest in this case. In my submission, my Lord, have not behaved improperly. I haven't sought in any way to demean my colleagues. The attack is on the case, my Lord. I don't personalize anything. The attack is on the propositions and the contentions advanced on behalf of the defendants.
Yes. Thank you, Mr. Mahon. Mr. Bokaba, you wish to say something?
It's not correct, my Lord. You and I know, and other colleagues, it started in chambers. This is not new. And I don't want to go back and disclose what happened in your chambers. But these nonsensical terms or fiction are ascribed to counsel. They are used in relation to comments made by counsel.
Well,
He can't be defensive about such an abhorrent behavior, with respect.
Yes.
Yes.
I have to strike some kind of a middle ground here. On the one hand,
Just to finalize, madam,
yes,
there are serious implications for all counsels involved in this matter,
When you
flowing
s-
from such utterances, madam. Some
Well-
pronounced, some not.
well, I'm not sure because, in the hurly-burly of trials, counsel has to accept that when there's criticism made, certain words are used. Like the word nonsense that you are objecting to. I hear it from counsels in court all the time.
But not in
But
relation
not
to your
not in a
case.
personalized
That's
way.
the point.
Now, if you've understood it to be personalized, Mr. Mohan has now clarified that he does not intend it to be, or did not intend it to be in that manner. Will you accept that?
No, there's no apology in there. It's not about what he says. It's what I feel about what he says.
Well, because speaking for myself here, I have not interpreted it to be any attack on any of the counsel here.
I have,
Eh,
and I
yes.
said there's a history to this.
Yes.
It's not starting now or today.
Yes.
Yes. It's a pattern of conduct.
Thank you, Mr. Bakaba. Mr. Mohan, anything more?
Nothing more to add, my Lord, on that score.
There is this issue about you not apologizing.
Well, my Lord, I can't apologize if I've clarified that it's not directed at Mr. Bukaba, my Lord. I thought I'd made myself clear. I don't direct these comments at him personally, my Lord. So to apologize wouldn't make sense, my Lord. I have nothing with respect to apologize for. It's regrettable that Mr. Bukaba has interpreted my submissions this way. My Lord, the greatest of respect to Mr. Bukaba, I can't be held responsible for whatever misinterpretation he drew.
Yes. Thank you. You may continue.
Thank you. What follows, my Lord, and to go through the minutiae, my Lord, would take forever, so I don't intend to do that, but broadly, Your Lordship sees that there's a description during the course of this study that was done of what was given to the participants of the study, how they were observed, how they were treated, what was recorded. Goes on page 68, my Lord, where it talks about these diagrams and it talks about the study having been approved by the Institutional Review Board at the University of California, San Francisco, the Research Advisory Panel of California, the Drug Enforcement Administration, the Food and Drug Administration, and the National Institute on Drug Abuse.
Mr. Oh, you want to finish that point?
Yes, sorry, my Lord, yes.
Yeah.
To say that these matters are irrelevant, my Lord, is with respect not correct.
Now, what I want to raise is, from the court's perspective, when articles are annexed here, is the presiding judge also expected to read everything there so that he or she is in a position to understand the arguments of counsel? Or,
No, my Lord, I'll tell you why, my Lord, by way of illustration. The nature of a scientific report is that it is often based on certain raw data. The raw data, as the Coopers and Gesellschaft case dictates, ought to be provided. You must say the facts and the data. You must provide it. The data might very well be completely incomprehensible to someone who's not familiar with the science. And so if reams of data were supplied, clearly, my Lord, a judge can't be expected to trawl through the reams of data. But the scientists, of course, they're not strangers to these things. So, and it's, again, it's not for the plaintiffs to assume that the defendants will appoint a suitably qualified and experienced scientist. They may or they may not. But this is the data upon which the scientists will rely, and therefore it must be supplied.
Yes. Thank you.
Yes, my Lord. Also point out, my Lord, that in the plaintiff's special trial note, it was specifically stated, my Lord, that your Lordship need not read through the annexures because your Lordship will be taken through it during the course of evidence.
Yes.
So, my Lord, at page 69, on the bottom on the left, here we have the results. Study patients. A total of 223 patients were assessed for eligibility between May 2003, May 2005. 55 individuals were enrolled. Of these, 27 were randomized to cannabis cigarettes and 28 were randomized to placebo cigarettes. One patient withdrew, and there's a figure, my Lord, above that, a table which illustrates the dropout rate, as it were, of the participants in the study and the reasons therefore. That your Lordship finds in a number of studies, that sort of process and protocol. This is what the study involves, so many patients, this is what we did, this is how they were excluded piece by piece, and ultimately you get down to a result. The result, for illustrative purposes, my Lord, would be that in 5 out of 10 patients there was a correlation, a statistical correlation between reduced pain of an average of 30 to 40%, and in 20% of patients there was a statistical correlation of reduced pain between 10 and 20%, whatever it may be. And from that, the expert draws the conclusion, my Lord, and if I go back to Dr. Abrams' report, his summary, I mean, page 9, para 3.1.6, this is the conclusion. Cannabis has been shown to assist in the management of painful HIV-associated sensory neuropathy. It's obviously because of the statistical association, and in order to test the validity of that statistical association, the data is contained, the description of the study. I can do that for many of the reports, my Lord, but it's a recurring theme, particularly in regard to Dr. Abrams. Professor Nuts is the same, my Lord. He refers to studies, he refers to observations, some in which he participated, some are opinions by other scientists which I've dealt with, my Lord. And thus, in our respectful submission, my Lord, it can't be said, can't legitimately be said that the contents of the annexures are irrelevant or of a general nature. Another thing, of course, my Lord, is, for example, in regard to how the defendant's expert, which your Lordship finds at page 264 is the summary. And if I could ask your Lordship at the same time to take the next file, my Lord, which is file 3 of 6. Turn to page 415. This This is an annexure to Dr. Howell's report. Given that what the defendants seek is to strike out all the annexures, this annexure is also under attack. It is under attack on the broad bases put forward that it is of a general nature and irrelevant. How that can be said of this report, my Lord, is curious. It's because this is the very report which served before His Lordship and the full bench, His Lordship Justice Davis and the full bench in Cape Town, in the Prince matter, which was reported, I think, in last month's law reports, where the full bench in Cape Town held that the present legislative regime, the very same legislative regime which is under attack in our case, was held to violate the constitutional right to privacy under Section 9 of the Constitution. His Lordship Justice Davis referred specifically to this report being submissions as amicus curiae to the Western Cape High Court in the matter between Jeremy David Acton, etc. Now, as was pointed out, we know that the judgment of the full bench in the Western Cape has been taken on appeal. We also know, my Lord, from what's contained in the judgment that how the matter developed in that case was that the court was dealing with unrepresented litigants and therefore called for submissions as amicus curiae from the University of Cape Town, and thus this report was generated. And the state, says the judgment, was given an opportunity to respond to the report. And the finding of His Lordship Justice Davis, unanimously supported, was that the evidence put up in response by the state was, and I use his words, my Lord quotes, singularly unimpressive. Some of that evidence which was put up in response will feature in this trial because it comes from some of the same experts which Your Lordship will deal with. But how the contention can seriously be put forward that this document is of a general nature and not relevant to the proceedings, when a court has already found, on the basis of this document, that the laws which are under attack here violate the Constitution, eludes me.
Well, just a point of clarification. I was involved in that matter, and it's on appeal before the Constitutional Court. That's all I want to say.
Yes.
Yes.
Thank you, Mr. Bukama.
Sorry, I did point that out.
Yes.
Now, my Lord, we are at somewhat of a disadvantage in the application because, as I pointed out right at the outset, the application seeks to strike out all of the annexures, not particular annexures. I can't, my Lord, with the time available to us, go through the exercise which I just did with Dr. Abrams' report in regard to every single annexure. We just simply don't have the time.
Yes. But reference was made by Ms. Kabasha to the one report where the expert has an MBA and he then is supposed to give expert evidence.
Yes.
Perhaps you could deal with that.
Yes. In the pleadings, my Lord, trying to find it, my Lord, if Your Lordship will bear with me. Look, perhaps in order to deal with this point, my Lord, I should deal more broadly with another aspect of the case because it will illustrate something which I'll use to answer your Lordship's question. If
Yes.
Your Lordship will permit me. That is this. The defendants say, my Lord, in the application, that the annexures are not relevant because the plaintiffs want full decriminalization and because of the Medical Innovations Bill. That, my Lord, the statement that the plaintiffs want full decriminalization is with respect to mischaracterization of the plaintiff's case. They say that, my Lord, in the first to seventh defendants' founding affidavit, page 9, para 16.
Where is that now?
In the founding affidavit in the strikeout
Oh.
application.
Page 9. Yes.
Yes, page 9, para 16. They say this. There is very little in these articles that address the primary claims of the first and second respondents that there is a case for the full decriminalization of the use, possession and or dealing with cannabis. Now that, my Lord, with respect, is a complete mischaracterization. I'm not sure why they say that the plaintiffs are arguing for full decriminalization. What the plaintiffs are claiming, the Lordship finds in the pleadings, in file 1, my Lord, page 33.
Yes.
You'll see how this evolves, my Lord. You said there can be no misunderstanding. You've been quite clear and pertinent about what the case is. Page 33 of file 1, my Lord, is the prayers.
No, I think then we're talking of different.
The very first divider in file 1 is the pleadings.
Yes.
Prayer 20, in paragraph 26.1, Lord, this is the relief that the plaintiffs seek. Declaring that the legislative prohibition against the possession and use of cannabis by adults is inconsistent with the Constitution and therefore invalid. What that immediately implies, my Lord, is that the plaintiffs accept, perhaps anecdotally, because it's not for your Lordship to determine the new legislative regime, simply to pronounce that the present one is unconstitutional. But the plaintiffs accept that they do not advocate for this substance to be in the hands of children. That's not their case at all, my Lord. In paragraph 26.5, my Lord, it's spelled out clearly. They want in order that the declaration of invalidity and the relief in consequence thereof be suspended for a period of 2 years to enable the legislature to pass appropriate legislation to regulate the cultivation, processing, distribution, sale, possession and use of cannabis. Not a wholesale decriminalization, a free-for-all. They say, declare what's presently in place is not constitutionally acceptable and tell Parliament that they must regulate it accordingly. That's what their case is, my Lord. But if that weren't clear enough, my Lord, the specific question by the 1st to 7th defendants about what is the plaintiff's case, and it was answered pertinently, my Lord. And your Lordship finds that, again, in the pre-trial bundle, my Lord. That's also in the same file 1. After the pleadings is the pre-amendment bundle and then the pre-trial bundle.
There are two volumes of pre-trial bundles. Which one?
The second one.
The second.
I'm referring to page 278. I've got it as a third volume.
Yes, I was about to say it's volume 3.
Page 278, paragraph 2.5. The 1st to 7th defendants themselves ask the question, is it the plaintiff's contention that cannabis should be allowed to be freely and possessed and used? The Lordship finds the answer at page 287. Paragraph 12. Answer. No. The plaintiffs contend that the use and possession of cannabis may legitimately be regulated by the state in a manner, sub 1, which is not irrational and inconsistent with the fundamental principles of the rule of law and legality, sub 2, which does not violate a person's constitutional rights under Chapter 2 of the Constitution, more particularly the rights referred to in paragraph 14 of the particulars of the claim, alternatively, which justifiably limits those rights. So, Lord, there seems to be a misunderstanding. How there can be a misunderstanding, one wonders, but there seems to be a misunderstanding that the plaintiff's case is the Lordship must declare that cannabis can be freely used. That's not the relief which is sought. What they seek is an order that the present regime is unconstitutional and let Parliament regulate in a fashion which is constitutional.
Yes.
Now, when one deals with that question of whether the present legislative regime is unconstitutional or not, there are a number of rights which are said to be violated, and there's also the principle of rationality. The departure between the two parties, my Lord, as we see it, is that the defendants point out numerous harms associated with the use of cannabis, whether physiological, psychological, or sociological. Mm-hmm. And they say those harms are causally connected to the use of cannabis, and they say that as a result of the existence of those harms, it is rational and legitimate for government to, on a wholesale basis, criminalize use and possession of cannabis. The plaintiffs, on the other hand, say, yes, in certain respects, we accept there are harms. We accept that there is a statistical correlation between use of cannabis and certain harms. We don't say in all instances that that necessarily means causation. But we say merely to look at harms is only one leg of the inquiry. In order to pass the test of rationality, one must then look at what are the benefits, and you must compare the harms versus the benefits. And you must also look at what are the harms of the present legislative regime, which presumes that someone who's in possession of 115 grams of cannabis is a drug dealer, even if he's using it for his own personal use. Throw him into jail, prison sentences, what the harmful effect of that has on individuals and society at large. So that's the true issue between the parties, and that's why, my Lord, we say with respect that there appears to be a misunderstanding that those are the true issues, because if there was recognition that those are the true issues, there would not be a suggestion that the annexures are irrelevant, because whilst it is so that some of the annexures relate to medicinal use, the fact that there are therapeutic benefits is something which the legislature must take into account. And we say, had they taken all the benefits into account, the legislation would never have been promulgated because it does not meet the test of rationality. Yes, my lord. And that's in regard to the primary claims of the first and second plaintiffs. Then we have the claim of the third plaintiff. I use the term loosely, but the medicinal use case, because Lordship may have seen much of what particularly the 8 defendants say is that that cannabis is not ready to be classified as a medicine. Further study is required. And in some instances, my lord, the experts are ad idem that further study is required.
I'm just a bit concerned. Are you still specifically dealing with the striking out here?
Yes, my lord. I'll try and keep
I
it
think
short,
you
my
might
lord,
be
but it deals
dealing a
with
bit more into what
the
we
merits.
should be dealing with in the merits of them.
I do it merely, my lord, to illustrate what the issues are, because we need to know what the issues are to determine relevance of the annexures.
Yes.
So, again, the medicinal use case, from the plaintiff's point of view, is not that it must be scheduled as a licensed medicine. What the third plaintiff says in his pleadings is he was cultivating the plant himself and producing his own oils for therapeutic benefits.
Yes.
It's something different to it must be scheduled as a medicine. So bearing those aspects in mind, those are the issues in the case. And your lordship asked me about the report of the expert Lysovich.
Yes.
He deals with the economic benefits of regulated cannabis industry. And there was also mention of Mr. Budden's report. Hemp. What does hemp have to do with this case? Well, my lord, the plaintiffs are not charged with the crime of being in possession for a particular purpose. They're charged with being in possession. So when the plaintiffs say, well, we want to use it recreationally, and we want to be able to manufacture clothing and chipboard and building materials and those sorts of things, those aspects come into play. The question of rationality features not on an individual case-by-case basis, but rationality is determined when looking at the legislation. Is the legislation rational if it criminalizes possession of a plant which is not necessarily even psychoactive? Because as the experts point out, you get cannabis plants which don't get you high. The male plants, as I understand it, can't get you high. It's the female plants that have the flowering buds which is used, they produce the THC. The male plants are used typically for industrial purposes, making rope, making chipboard, building materials. And so one tests the legislation against the rational question, is it rational to criminalize possession of cannabis on a wholesale basis on the basis of the professed legitimate governmental purpose being we don't want people to become drug addicts or suffer these harms, when that portion of the plant, none of those harms are actually associated to it. So that's where it becomes relevant.
Yes.
And as for the economic use, my lord, that's also a question of rationality, because we're dealing with the interests of the public at large. The public at large's interests are met, we say.
Are we not veering off again?
Yes, I'll wrap up with one submission on that point.
Yes.
Lord. We say that the public interest at large is met by an economic benefit which the public receives as a result of the use of cannabis, its taxation, etc. Yes, that was, my Lord, specifically in answer to the MBA question, my Lord. I hope that satisfies.
Oh, is that to deal with the MBA issue?
Yes, my Lord. So the I think it was Lycevic who has the MBA. He's the one who says, well, I'm a businessman. I know that the positive effects of this industry could have on business, society at large. It all goes to the question of rationality, against which the legislation must be tested when considering whether it meets constitutional legitimacy. Lord, I don't have the time to go through all of the annexures. Had they identified particular annexures, I might have dealt with them more particularly, my Lord, but it's a whole scale strikeout application. That's what makes, in part, what makes it vexatious, my Lord. We're required to now apply our minds to each and every annexure. Does that annexure actually meet with your complaints? Does it not? That's vexatious in and of itself. It's vexatious, my Lord, because of that. It's vexatious because of the lateness. And it's vexatious because of the numerous attempts that the plaintiffs have made to try and bridge the impasse between the parties through a facilitation of an experts meeting, which invitations, my Lord, have not been taken up. And so therefore we say, my Lord, that the application ought to be dismissed, that it justifies costs on the attorney and client scale, obviously costs of 2 counsel, my Lord. The fact that they're themselves guilty of the very complaints that they raise, my Lord. And in the affidavit, my Lord, to say that they can't have an experts meeting under oath, they say that, and concurrently with that, my Lord, their representatives are suggesting the facilitation of an expert meeting, my Lord, strikes of some serious contradiction, my Lord, in the approach, which we say leads one also to conclude to the vexatious nature of the application. And so, my Lord, we would ask that the application be dismissed on the attorney and client scale. I'm just going through my notes, my Lord.
Yes.
Lord, yes, we would ask for dismissal of the application on an attorney and client scale. Those costs to include the costs consequent upon the employment of 2 counsel.
Thank you, Mr. Mahon. Ms. Kabasha, in reply.
As the court pleases. Your Lordship, might I ask for an indulgence?
Yes.
And start tomorrow morning with the reply. Reason being that the plaintiffs have gone very much beyond the scope of the issues that were raised. They've raised many new issues. They've raised details that we had hoped would be raised on the merits, Your Lordship. We tried to avoid dealing with matters that would be raised on the merits. There's quite a bit of preparation that needs to be done just to put this court in a position to understand the case that the defendants have sought to make out in this application to strike out. In any event, Your Lordship, when I look at the time, it's almost 3:45, and there are 2 of us who will have to be replying. So I ask for the indulgence of this court, in the interests of justice, really, and fairness, to give us the opportunity to give this court a detailed, short, but detailed response.
Yes, I'm just concerned because that this is now at the stage of reply.
Indeed,
and you
so
say you intend to reply. I did tell Mr. Mahon that he's veering into the merits, and so I'm not going to consider anything he dealt with about the merits unless it has any direct relevance to the strike-off application. So because I heard you say in your opening remarks now that you may want to, if I understood you correctly, also deal with the merits.
not at all, Your Lordship.
Oh.
I'm saying only to the extent that they relate, they have been raised by Mr. Mahon,
Yes,
and they relate to matters that we have put on record.
I see.
And we will give short answers, but comprehensive, Your Lordship, to the
Yes.
plaintiffs.
Do you wish to? Did you wish
Well,
to say?
I'm not one to quibble with colleagues who need time.
Yes.
Generally speaking,
Yes.
I'll just make this observation. Your Lordship in Chambers suggested very graciously, my Lord, that Your Lordship would, on an ad hoc basis, be prepared to consider a request that we start earlier. I'm not sure if, in light of what is developed, we should perhaps start earlier tomorrow if that meets with Your Lordship's approval.
Yes.
That way we could make up some of the lost time.
Yes. What is the view of Mr. Kabasha?
Your
If we were to start at 9:30 instead of at 10 o'clock,
I'm sure that's in order, Your Lordship.
would you
We
be?
start, yes. I just think it's rather rich for Mr. Mohan to be the one who raises the issue of time, when he, at 20 to 1, asked for timeout and took all of between 2 o'clock and 3:45.
No, it wasn't at
complete.
22. It was, I think, 8 minutes to 1.
Oh, my apologies. My senior is correcting me as well. As Your
Yes.
Lordship said that, my senior corrected me as well. My apologies, both to the court and to Mr. Mahon. It was at 8 minutes to. My senior is correcting me. I have no difficulty in apologizing, Your Lordship.
No.
And I do apologize. Yes. But the point really being that
But
we
this
need-
was
we-
not
we need
yet-
the time.
I already suggested this yesterday, because that if the parties are amenable to that, we could start a bit earlier on an ad hoc basis. I'm not saying every day. And now here is a suggestion that, because personally I was hoping we would finalize the striking of application today so that we can get on with the trial tomorrow. Now, I'm not sure how long now it will take tomorrow morning for the striking of application, because I would need to consider your anything else you say in reply. But be that as it may, would 9:30 be in order?
9:30 is in order, Your
In order.
Lordship.
Mr. Willis, for you, 9:30. So then we adjourn until 9:30 tomorrow morning.
It's